Welcome to First Line Compliance's Carefully Off the Cuff.
Hi, everyone. Welcome back to Carefully Off the Cuff. I'm Josh.
And I'm Ray. We're First Line Compliance. Hey, today I just want to kind of discuss a couple things we're seeing in the industry, mostly enforcement actions, a little bit maybe more examinations, but some trending issues that are not alarming. It's just good to bring it up and keep checking to what things are happening. And maybe it's happening to you and you think you're the only one. So maybe we'll figure something out. Okay. So I got a little list here. Let me go in a few things, Josh, that I kind of uncovered and looking at some of this. California Department of Real Estate, they're issuing some citations. I've heard this now. It's kind of like they don't do many audits, remember, Department of Real Estate. So but they do find issues. They'll issue a citation. And so you have to pay the fine or you can contest it. What I've been finding these are mostly based in marketing. In one instance that I'm really familiar with, the review of the marketing was in 2020. And the citation was issued 2 months ago, now in 2023. Very strange. And by the way, they don't even give you the documentation to see what they saw, to see you can contest it, on its face immediately. They don't do that. There are some citations on that. Again, no harm, no foul. You pay the fine, don't pay the fine. You can contest it, find out what the issues are, because they will eventually get it to you, is how I understand it. But again, just something to think about, that the Department of Real Estate, which generally is not that active, got a little bit active by virtue of citations, and it looks like marketing is the key there. Arizona, and I've heard this before, they're coming back in circle. Go ahead. Sorry,
Ray. Yeah, real quick before we pivot off of California. Sure. DFPI also very involved. A couple of findings that are recurring: failure to file the annual report on time. So if you're a non-HMDA filer, your Holden Act report, the DFPI annual report, just the fact of not filing and meeting the deadline often leads to citations and issues.
Correct.
Similarly, pretty frequent that comes up in exams, two that I see a lot: one, not getting per diem interest calculations accurate, and two, listing more than one or the wrong regulator on the California Fair Lending Notice.
Yep.
Really important that we check those, that we're doing a self-review to make sure that the per diem interest we're charging is within the tolerance, and if not, that we're refunding, and then we're getting the documentation to substantiate that we're doing it correctly. On the the Fair Lending Notice, making sure that often what we see most is listing both DRE and DFPI. I say this jokingly, so don't take offense, my friends at DFPI. I kind of think they change their address every year and a half just to see if lenders are paying attention and update the address.
Exactly. No, in the grand scheme of things, and they don't necessarily, depending on how often you do it, but the point is that these are things in examinations we'll find. Some things are more enforcement based, as we talk about, some things are examination based, to keep in mind. And also, don't forget, don't leave blanks, right? So if you got something there, don't leave it blank. Either put NA or get it out of there if you don't need that field. Arizona, real quick. Arizona, they're hitting, it happened in the past, looks like they're doing it again, hitting lenders for engaging lead generator companies who aren't licensed in Arizona. Now there are, and I have trouble sometimes people believing me on this. Lead generator companies have to be licensed in a few, if not several states now, right? Arizona being one of them by virtue of definition, if not edict, by the state of Arizona. And often they're not big enough sometimes to think about licensing, but that's a big issue. So Arizona is now looking again at lenders who are using lead generator companies who are not licensed, as I guess to be a broker or whatever. But that's something to think about. Again, I'm not here to tell you who to engage and not engage, and whether they're right or wrong. I'm only telling you and reporting to you what I'm hearing. I'm not telling you my legal opinions as to whether I think it's valid or not. It's not my goal here.
Yeah, Arizona is strict in all regards related to unlicensed activity.
Yes.
Really important that we have the confirmation that we know, really from the vendor management and third-party review, that people we're working with have the authority to conduct the business. So if it's a lead generator that's required to have a license, the lender will be held liable for engaging an unlicensed participant. So even if that company, the lead generator, doesn't have a license, Arizona is going to come after the lender that does for not meeting the licensing requirements.
Correct. So now, and you're right, but real quick, loan officers too. If you're a loan officer and you didn't change your address and they figure that out, they're not amused. So and somehow they'll drag in the lender again. But it's like, hey, you guys have the relationship with the MLO, we don't. But anyway, you're right about the sticklers on licensing.
One other point, then this happens a lot that I've seen, honestly, in most Arizona exams, It's a violation related to the blank spaces disclosure. So Arizona has a requirement. They have a blank space disclosure where if you're going to issue a disclosure that has blank spaces, you have to identify what it is and what fields are blank. Most lenders are cited for having a blank spaces disclosure. So if you don't issue disclosures that have blank spaces, don't include that disclosure.
Yeah.
Well, one other quick theme that I think we'll talk to across the states, and that is repeat findings.
Mm-hmm.
If an examiner or a state identifies an issue and you're cited for it, more than likely they're willing to see what your corrective action will be and anticipate that you will correct it. If they come back and see that there's a repeat finding or a repeat violation, they're going to take you to task for it. If you see it 3 times in a row, expect a civil monetary penalty. They will be more severe because it identifies either 1, you're not taking them seriously, or 2, the corrective action you're taking isn't working. So they're going to involve themselves more to ensure that that repeat violation doesn't reoccur.
So just don't have repeats the best you can, is really what it comes down to. So next, I wanted to talk same thing. There's a theme that I'll be coming down here in a minute. The CFPB is going back. This is not really new. I think the last several months, they've been looking at consent orders and coming back to people who they've issued consent orders and see if they're complying. So going back to the repeats, it's one thing to have a repeat finding with an examiner in a routine state examination, which is bad in its own right, but to have a consent order and have a repeat consent order, if you will, by the CFPB, that's not good. So if you do things, I guess the message there, and again, I'm just taking the facts as I see them as they're issued by the regulators. But if there's a repeat there, you have to watch out for that. So if you said you were going to fix your marketing, you better fix it, because if they catch later, they are not amused. So issuing a reconsent orders, which we do see a theme of that, and they've actually been open about that. They're coming back and checking to see people are doing the thing they're supposed to do. If you're not doing it, that's a problem. So that seems to be a theme, and I just say that because CFPB is they have the resources and time, and maybe they should, to not just do standard enforcement actions and examinations, but also go back and see what they've done. We think they don't do that, but guess what? They're doing that. The other ones I want to say, CFPB also, I thought this was interesting. The CFPB has filed a lawsuit against, I want to say, owners of a company where in a consent order and enforcement action before they had a judgment. Well, it turns out, at least again, as alleged in the orders here, in this case litigation, that the owners were hiding their assets. It's like it's a trust or family trust, where they're hiding their assets, and now the CFPB is not amused, and now they're just going to write out and sue them for it. So it's a different action. This is not a classic enforcement action. This is litigation. They're going after somebody because they want their damn money. Right, wrong, or different, that's the situation. But I thought that was interesting. Again, this goes back to the point of the CFPB are taking steps of not just your routine examinations, and I wanted to not even routine enforcements. They're taking extra steps to flex their muscles as to who they are and what they're doing. Josh, you had some thoughts?
I think that's spot on. And in the case you were talking about, it was a company who was fined, who didn't pay the fine, but then the husband of the company was taking assets and putting it into a trust that he was a trustee of, and it was the wife's trust. They saw that as moving money to evade paying the fine.
Correct.
As Ray said, they weren't too happy about that.
No, those are the facts we don't know. I mean, as alleged, we don't really know, but yeah, exactly.
And just also to say, I think what we've seen from the Bureau is they're willing to go to court on these issues. That they're willing to press novel or potentially novel theories and saying, well, lender or company, prove me wrong. I think that's a potentially puts lenders on a potentially vulnerable position, because the cost of litigation, the cost of defense can be expensive. Mm-hmm. And so when this happens, avoid it at all costs. Avoid getting caught up in the litigation or the enforcement. If it does, there's going to need to be a really good counsel and representation to help you evaluate the risk of settling or the risk of not.
Exactly. So the last one I want to bring up, and it still goes to the theme here, is the state of Washington. Washington is pretty, in our experiences, I mean, all states are good and fair, right? But the ones who are I think one of the most prolific states out there in regards to enforcing and flexing, particularly in the marketing realm, is the state of Washington under the DFI, under the Consumer Loan Act primarily, but anyway, the DFI. And good, bad, or different, but that's the situation. So they've issued a consent order on a company, again, who did some marketing, which usually is the sweet spot for the DFI. In this context, they were not getting the information from the lender like they're supposed to. In other words, they requested the information, the records, the advertisement to look at, and for some reason, the lender wasn't able to produce. Now, again, I don't know the facts. I can only tell you how it's reported. Whether they didn't have the information, didn't exist, or they were holding back and shouldn't have, I do not know. But the Washington Department of Financial Institutions took action again, the consent order for not responding to the request. And in fact, I think it was a recurring consent somewhere else in there too. But the point is that that's again, they're flexing their muscles as well. So the states are starting to, they always flex muscles. I just had to report back on things that I've heard recently, and really common trends. It's don't look out for the repeating issues if you can. So if you got something, get remedial action and actually invest it and keep it there. Marketing seems to be a theme. So whether it's lead generation companies or the actual marketing, otherwise appearing to be deceptive or issues or whatever, that seems to also be a theme. There's other things, of course, but that's kind of what I've been seeing and normal things. Look, go ahead, Josh.
Sorry, yeah, let me jump in on Washington. I actually want to give kudos to Washington. They hold regular webinars or engagement meetings with industry and the public, so that none of this is a secret. They actually publish their meetings and their notes online. They're available on the website. They say the number of exams they have, the number of enforcement actions they have, common violations they're seeing. It's one of those where knowing what to look for helps us avoid the issues. So a couple that the state has raised, and I think they're really helpful to point out and specific to Washington. One is Washington's requirement is you include the link to the company's NMLS profile, not just the link to consumer access, but the link to the company's specific page on consumer access. So you have to enter the code, the Turing test, in order to get there. But after someone puts the Turing test code in, their expectation is that link goes directly to the company's website. So one thing to keep in mind. Also, and that they've seen in enforcement actions, we've talked about a lot, inaccurate mortgage call reports, failure to provide the required information in advertisements. And one that I think that's particularly important, they've actually cited it under misleading and deceptive practice. And that's if a mortgage lender or a mortgage broker is issuing a pre-approval or a pre-qualification without actually reviewing the criteria, not running the loan through an AUS, not performing their own assessment or qualification that the borrower applies. So saying lenders, brokers, before you issue a pre-qual or a pre-approval letter, make sure the borrower actually qualifies. And if you don't, be prepared to be cited by the Bureau, by Washington. And your way to refute that is providing the documentation that you actually did do the qualification or screening of the borrower before you issued the pre-approval or pre-qualification letter.
So really there's two takeaways here. One, keep your nose clean, right? So do it right the first time, whatever that might be. And I trust everyone tries to do that. It's just sometimes it slips or something happens. I respect that. And then secondly, if something comes up from a regulator, whether it's a consumer complaint, or everything from they want to start taking action against you, that's what it looks like. It might be some litigation or enforcement action and everything in between. Be thoughtful in that approach. So certainly treat the regulators with respect. They're just doing their job, as it were, and be timely, be complete in your responses. And then if you really need, and I think that's almost always the case, maybe not consumer complaints, but certainly other ones, make sure you talk to a compliance or legal professional when you get some of these, because maybe they're wrong. I mean, as much as I hope to upset them in state examinations and other areas, sometimes it's actually a misinterpretation of the law. They're actually wrong. But understand, what your rights are. How many days do I got to respond? And wait a minute, I think they're wrong. How do I contest this? They don't mind that if you do it properly, and respectfully. So make sure you get someone who understands not just the facts, but actually the law and regulation and how the cards move in the game of regulatory enforcement. Make sure you talk to somebody about that. It could be us, it could be otherwise, but just be aware of that.
Let me just add on there, because I think that's really important. Working with someone who is both knowledgeable about the specific findings, the examination or enforcement process overall, and the regulators you're dealing with is really helpful. It's not going to be bulletproof vest. If there's a violation, even though we may be friends with the regulators, it's not going to get you a get out of jail free card. but it does allow the conversation. We've been fortunate to work with several clients that we've been able to work through and mitigate some of the more significant findings that came up in a consent order, and work with the department to appropriately explain and demonstrate why what might have appeared on its surface was not nearly as severe in reality.
Absolutely.
And the result ends up with a lower fine or no fine, or a resolution that's far more favorable to the lender or the broker or the financial service company than it would be. The point to take away: do not ignore it. This will not go away if you sweep it under the rug. It will only get worse.
As you saw in the Washington DFI issue, it's just like if the facts are as they say, right? It's like just ignoring the fact and not giving information that they're requesting. That doesn't go well. Respond as best you can, and don't be afraid. Just lean into it and find out what you got. But I agree, absolutely. Okay.
Well, Ray, I think this was super helpful. Maybe I'm a little biased. We'd love to hear what you think. As always, please rate, subscribe, review, and we'll see you next time.
Thank you.